Dear students, in this lecture we'll talk about the protection of environment in current Indian legal system. Before going in the details of the topic, give a thought as to how many of us actually think of environment protection and how many actually make step forward for protecting the nature. First of all, we'll take a look on preservation of natural resources. The question arises as to whether protection of environment is enough for better sustenance of living for present and future generations. The answer is no. There is a need of simultaneous actions for improvement in the environment, that is, increasing the natural resources. For example, in case of hunger, do we ever recommend reducing our appetite or we prefer increasing the food stuff? Thus, everybody who is consuming the natural resources must act in furtherance of promoting or improving the environment. Now, let's have a look at the quote provided by Robert Swan. The greatest threat to our planet is the belief that someone else will save it. It implies that if we have right to cherish the fruits of environment, we have a complementary duty to protect and improve the environment. Moving on to the historical background of environment law, this can be classified into four phases. First is the ancient phase. This is considered as Vedic period where plants and animals were considered as abode to gods and goddesses. The five natural elements being water, air, soil, earth and food grains are the natural resources to be preserved for not only the present but also the future generations. Theory of karma laid emphasis on the principle as you sow, so shall you reap, means that one will bear the consequences of the act he does. Second is the Mughal period. In this period, less importance was given to environment, although Mughals were fond of beautification, which led to creation of gardens and fruits and flower orchards. Hunting was the major sport during this period, leading to killing of animals, ultimately adversely affecting the biodiversity. Third one is British era. This is the awakening era from the legal perspective, as during this period, Britishers laid emphasis on enacting certain legislations for protection of environment. Several laws in relation to forest and wildlife conservation were created. The ulterior motive of making such laws was not the improvement of environment but to collect revenue from the same. And finally, the post-independence era. This is the landmark period which reflected growth in protection and improvement of environment. It relied on the lines of Mahatma Gandhi, a selfish man overutilizing resources to satisfy his needs is thief, because using resources beyond the needs is using the resources on which others have a right. The landmark fundamental, that is the Constitution of India, provides for protection and improvement of environment. By virtue of 42nd Amendment Act 1976, Article 48A and 51AG were added, which provides for the complementary duties of state as well as the citizens to make efforts for protection and improvement of the environment. Let's study about the legal fabric around environment protection. There are three categories, namely constitutional, statutory and international. Constitutional framework relating to environment involves Article 21, 48A and 51AG. Article 21 as a fundamental right provides right to life and personal liberty, which has been given an expansive interpretation by the courts, stating it includes right to clean, healthy and wholesome environment. Any disturbance of basic environmental resources which are essentials for life would be hazardous to life within the meaning of the Constitution. This right to live in a pollution-free environment is reflected under a series of cases like Subhash Kumar versus State of Bihar, Pollution Control Board versus M.V. Naidu. Article 48A as a directive principle of state policy provides that state shall endeavour to protect and improve the environment and to safeguard the forests and wildlife of the country as provided in Virender Gaur versus State of Haryana and Indian Council for Enviro-Legal Action versus Union of India. Article 51AG provides a fundamental duty of every citizen to protect and improve the natural environment, including forests, lakes, rivers and wildlife, and to have compassion for living creatures as provided under M.C. Mehta versus Union of India. Statutory framework relating to environment involves the Environment Protection Act 1986, the Forest Conservation Act 1980, the Wildlife Protection Act 1972 and the Biodiversity Act 2002. The international principles are implemented by the courts under writ jurisdiction for sustainable development. It implies that sustainable development is essentially a policy and strategy for continued economic and social development without detriment to the environment and natural resources on the quality of which continued activity and further development depend. The important principles are intergenerational equity, precautionary principle and polluter pays principle. Now students, we move on to the last topic of our session, which talks about environmental impact assessment. It refers to the evaluation of the effects likely to arise from a major environment project significantly affecting the natural and man-made resources. Environment impact assessment is a systematic and integrative process developed in US, but recently in 2006, Ministry of Environment and Forests promulgated a notification on EIA in India which provides for the procedure to get environmental clearance from the concerned authority. Economic efficiency must necessarily equate with social and environmental welfare. We complete this session with an environment friendly note, Go Green. Hope you have got a good insight on environment protection under Indian legal system. Have a good day. Thank you.